Before they start, can I take only 2 minutes, my lord? If your lordship permits, my lord, I had my chance. My lord, first of all, Lord, as I have initially indicated, I have not taken any stand. I was to assist your lordship, my lord, broadly, and that's how my note also reads. My lord, my arguments are over. My colleague, Mr. Natraj, my lord, appeared for core and also, my lord, for the institute, my lord, and he had given his own suggestion, because these are all ultimately broad ideas which we discuss. Lord, so far as multiple account holder clients like, my lord, NBFCs are concerned, my lord, I could not complete, my lord, because of the lack of time. My lord, I had given a solution, my lord. Instead of individually every institute maintaining a list of arbitrators or panel of arbitrators, etc., there is a system going on, my lord, which is recognized by governments, recognized by the High Court of Bombay, and there are many such institutions where, for example, my lord, a person who takes loan of 50,000, Schedule 4 minimum fee is 45,000. So it's not workable. Well, the only thing which can, my lord, in my respectful submission, be done is to direct resorting to, my lord, this medium. There are several institutes, my lord. Only for example, if your lordships can, my lord, for a second, take 1998, my lord. Volume 5, my lord, of my submissions, my lord. This is one example, my lord. And this is, my lord, banks are using this for small, my lord, loan.
What are they doing?
ODR, my lord, that is online dispute resolution.
But that is just the format, whether it's physical or virtual. Who's the arbitrator?
Yes. Lord, my learned friend is aware. You can.
Because there is a comprehensive list of arbitrators empaneled by these institutions, for example, Sama and Lords Resolve. All kinds of arbitrators are there, Lords technical as well as Lords former judges who are empaneled. And Lords, the fee schedule is Lords
affordable,
tailor-made to disputes like these. Sometimes the arbitrator is already aware that if a dispute comes to him, he would be paid 2,000 or 5,000. Most of these awards are given in a 45-day time period. And there is no interference of either of the party. They have already incorporated a clause in their loan agreement that it would go to a Presolve or Sama or somebody else who's an ODR platform. So, Lords, the
$1.2 billion disputes are under the management, my lord,
of this particular institute.
of one institute.
The question is whether the NBFCs can themselves appoint an arbitrator and say, look, we are going to send this dispute to you. That's what Ms. Diwan was justifying yesterday.
My lord, therefore, I started by saying that this is an issue where our, my lord, focus on this side should be to ensure that the arbitration as a mechanism is strengthened. And therefore, my lord, I started by saying that any argument on either of the extremes would do, my lord, harm to the cause which we are, my lord, or concerned with. My lord, therefore, my lord, instead of few instances where they have multiple people to deal with, my lord, that can be segregated, because otherwise, my lord, the major chunk of arbitration is, my lord, not these people. My lord, they have major chunk, my lord, 10,000, 5,000, 15,000 depositors with small deposits, etc. Lord, at the cost of repetition, Lord, I advisedly did not, my Lord, raise any issue whether core is right or TRF is right or Perkins is right or one is wrong and other is partly right. Whatever your Lordship finally decides will govern the field. Your Lordship need not go into individual judgments, my Lord. On principles, my Lord, we have addressed your Lordship. There are, my Lord, several other institutes. Yesterday I came to know, my Lord, banks. They have small deposits, but they follow this kind of procedure. And the arbitrators are appointed by such institutes. And if your Lordship sees, my Lord, the Board of Governors or Advisory Council, eminent people, my Lord, former judges of this court, Justice Sri Krishna, former Chief Justice, my Lord, Justice Lalit, etc., they are there. So these are, my Lord, well-recognized institutions dealing in arbitrations running into the quantum running into some $1 billion. But individual claims are smaller. It's meant for smaller.
Now, who's going to argue now?
Grateful.
Mr. Padmanabhan?
I'll take just 3-4 minutes. But to supplement the argument of Mr. Guru Krishna Kumar, that 11.2 is conditioned by 12.3 or section 12 itself. Lord, my point would be, Lord, Act doesn't bar appointment by one party. That has been argued by everyone. Lord, the further submission would be that there is an implicit recognition of one party appointing an arbitrator. For that, Lord, I will just highlight two sections, 11.2, 12.3 and 12.4, and then coming back to 11.6.
Yes.
Lord, 11.2, I need not read, Lord, I read, so many people have read, my lords. But I'll just read, Lord, what happens, my lord, if once an arbitrator is appointed by one party, Lord, whether the other party can challenge that appointment? If yes, my lord, under what circumstances? Lord, answer lies in 12.3 and 12.4.
Yes.
Lord, 12 starts with, my lord, obligation on the arbitrator to disclose the circumstances, if any. Lord, 12.3, an arbitrator may be challenged only if circumstances exist that give rise to justifiable doubts as to his independence or impartiality. Here, my lord, where the arbitrator himself discloses, the party may continue, waive the rights under section 4, or he may say, I don't want you. But then, my lord, 4, a party may challenge an arbitrator appointed by him in whose appointment he has participated only for reasons of which he becomes aware after the appointment has been made. Where, my lord, this, my lord, takes into a situation where arbitrator doesn't disclose. These are the only two situations, my lord, under which, my lord, an appointment of an arbitrator can be challenged.
Yes.
Lord, there is no challenge prescribed that appointment made by one party can be challenged by the other party on the ground that it has been unilaterally done. Because the 11.2 itself, my lord, is an agreement between the parties to appoint an arbitrator.
For 12.4, what's the other one?
12.4, my lord, is a situation where, my lord, arbitrator doesn't disclose.
What is 12?
Pardon, lords?
12.4 and 12.6.
12.3 and 12.4, and then finally 11.6, my lords. 11.6, when does the court intervene, my lord, in such cases? 11.6, my lords. Where under an appointment procedure agreed upon by the parties, again 11.2, a party fails to act as required under that procedure. Lord, only in these circumstances, for example, my lord, I am the person to appoint an arbitrator. The other party gives me a notice that you appoint an arbitrator. This is a dispute that has arisen. I fail to appoint an arbitrator. In that situation alone, I can go under, my lord, invoke 11.6. My lord, under no other circumstances, my lord, intervention of the court comes into picture. Therefore, my argument, my lord, the appointment by one party is implicitly recognized, my lord, under these three provisions. That's all, my lord.
All right, thank you.
Great.
Now, Mr. Dubal.
Yes, my lord. So I am appearing from the IRCON, my lord. It's a railway PSU, and much has been said about us. We have a panel, plus we have circulated 9-pointer yesterday, point of submission.
Yes.
I'll read, the first to 7 are basically, it was said by the union. We go by that, as said, the freedom to choose runs through the act. And this is nothing to be said, and unilateral appointments are not prohibited per se, And with context of PSU, which is railway PSU, IRCON, we have to say, yesterday was said that the claim has become now a new revenue source. And why I am saying so, there's choosing from the panel, they had the freedom to choose, and they had the freedom to say this chosen by us is not a fair person. That freedom lies in 12.3 and 12.4, which I read right now, In this particular case, we had given a complete panel of 31 persons, and we circulate the entire list to the respondent. It can be seen, volume 4.
That's okay. That's the facts of it.
So, and this bias has been said thoroughly, bias is to be presumed. But according to us, bias cannot be presumed. It needs to be demonstrated. Yes, that's submission.
Thank you. Now, for the parties now, I think Mr. Shashank Garg, you wanted to argue for 5 minutes? For the Union of India, though, we have heard the solicitor, we can hear you as well.
Only on the aspect of prospective overruling, because that was not covered by the London solicitor.
What are you arguing?
Because there is a fine distinction that this honorable court needs to keep in mind. What is being argued today is an extension of the reference. So, the prospective overruling being sought by this side is to prospectively overrule the impact of TRF and Perkins. That in my understanding neither is the scope and nor should be entertained, because if that prospective overruling takes place, then several awards which have been set aside and arbitrations have now started de novo, all of them will get impacted. And if the Lordship are ultimately going to prospectively overrule, it would mean the Lordships are going to uphold what has been held in TRF and Perkins. That means that law has always been good law. So there is no question of opening those awards or those outcomes which are getting impacted by Perkins and TRF. Because as far as the core is concerned, because my submission is the clauses which are like core.
What is he saying? That
There's only one more submission. As far as the clauses like core, where the party has maintained a panel and has given some choice, whether limited or a free choice, that's a question that Lordships will ultimately determine. There, There also, there has to be a retrospective impact of the judgment, with the only exceptions of cases where awards have come. Because if the award has come, that means the parties have participated in the arbitration, have accepted the panel, had an opportunity to challenge, no challenge is pending in either court of law. So wherever awards have come, and the clause is akin to core, just a follow-up of this would be wherever this is presuming what the outcome of the judgment would be, speculating that, but application of section 15 would be required instead of asking parties to go and file a 11, wherever these parties are impacted by a clause which this court ultimately holds as bad, they should move for a substitution under 14 and get an arbitrator appointed in 15, so that the arbitration can commence from the stage it was stopped, rather than setting the clock back. I'm so sorry.
Hardly matters.
Is appointed under the same procedure as far as the original arbitrator is concerned?
Yes,
The 15.
yes, but if
No,
this honorable
because,
bench,
suppose because of some incapacity or something, arbitrator A is appointed
Lordship.
and he has to be substituted. The substituted arbitrator gets appointed in the same process as arbitrator A was appointed, or what?
Yes, there is an application that can be moved before the court, and the court will give due credit to the clause. But if the clause itself has been held to be illegal or not valid, then court would
Suppose there's no reference to the clause about invalidity or anything. A particular procedure is prescribed under which A is appointed. A becomes incapacitated. Then B is to be appointed by following the procedure,
same procedure.
leading to appointment of A. Is
Same
that
procedure without interference of the court, in normal courts. If there is no interference of court,
correct.
the same procedure will be applied. So it should not be a case where everybody is made to file a fresh section 11. Wherever any party is getting impacted in an ongoing arbitration, it should be a case for substitution from that state. So their grievance is also met, that so that yes, that's all. Grateful,
We have some interveners. Now, can the interveners really give us all a set of submissions? Because otherwise there'll be no end to it.
Well, I've the first of the, because I've given your lordships my skeletons.
All right, let's start with Mr. Jetmalani and Mr. Jetmalani.
Well, I've given detailed written submissions at
Just
5E.
Just tell us what is your point?
I've also proceed in the lunchtime my written submissions. So if your lordships want, I've emailed it.
Just tell us what is the main point that you're arguing.
Yes, but I have basically 5 points, and I first want to show your lordships the reference order, because an objection is taken that TRF and Perkins can't be revisited. But under the reference order, those who are opposing the ban on unilateral contracts have to go into TRF and into Perkins and see whether they're correctly decided, because there's a fundamental objection that legislative intent is manifest in unambiguous words by the 7th schedule. That doesn't provide for any ban on any of the persons mentioned in the 7th schedule to appoint arbitrators. That's not an extension. It's an extension first in TRF, and then Perkins has extended TRF to unilateral contracts. But TRF was concerned with a very limited issue, and that is the issue of when a managing director, post 2015, who had a power under an arbitration clause to arbitrate himself, once he was disqualified, could he then appoint an arbitrator? And that's the answer which they
So we got your point. You are saying that there's no bond, there is no ban on persons mentioned in the 7th schedule appointing an arbitrator.
arbitrate. But that's a fundamental point, because legislative intent is clear. Now, from the seventh schedule, because if, just to give one example, if they wanted to ban appointment of an arbitrator named in the seventh schedule, they could have just added one more clause in the seventh schedule and said persons appointed by arbitrators appointed by persons in clauses 1 to 19 above. So that's
Thank you, Mr.
no, just one minute.
Yeah.
But now, my lord, something on the two judgments. My lord, TRF and Perkins, my lord, in as much as so, my lord, TRF held. My lord, this is the starting point.
But tell us, does the 10th schedule apply to arbitration or not?
My lord,
Does the
no, that's
10th schedule?
the new. Frankly, I have not. I have.
The reason I asked you whether the 10th schedule applies
Yes.
is because the Solicitor General has now come to this side.
I see. I didn't note that. I'd have probably picked it up, but I didn't notice that move from your
Sir,
side.
I gave reason to my.
I didn't know what I did. He made a declaration in the beginning.
But I can
That he
tell
will
what
sit
I
either
said
way.
to my learned friend when he was surprised that I came and sat here. I said, you are the best person to tackle the situation where one party who is supposed to be in opposition sits together and you represent them.
But in an extension to that animal kingdom reference of wolves and my lord, he's running with the hare and hunting with the house. Good. Now, of the reference order itself, if I am to argue, if I am to defend unilateral contracts, I have to say a word on TRF and Perkins. Now, I've given a detailed submission dissecting those judgments, but just, if your lordships want, I'll hand over and my submission on those two judgments. I'll just give your lordship. It's very. I'm going to read it out. Basically, it won't take me more than 5 minutes.
All right.
But really, 3, 4, and 5 are the ones about the three leading judgments that impinge in this case, this reference.
In fine print.
And then, my lord, just 6, 7, and 8, my lord, is a defense against, my lord, the much maligned NBFCs. My lord, I'll start from clause 3. TRF held an MD who had also an additional distinct power of appointment, ineligible to appoint an arbitrator, because, my lord, in my respectful submission, it fallaciously conflated the power to appoint an arbitrator with the power to delegate its own powers to appoint an arbitrator. Well, I've dissected that judgment in detail in my 25-page written submission. It thus invoked the maxim, qui facit per alium, facit per se, i.e., what one cannot do, he cannot do through another. The arbitrator is an independent appointee and not the alter ego of the person appointing him. Well, that's as far as TRF is concerned. Then, Perkins extended it to all unilateral contracts. Perkins extended the principle in TRF to all unilateral contracts on the basis of what it construed to be the rationale in TRF, that the arbitrator appointed by a person ineligible to himself act as an arbitrator by virtue of the disqualification of the 7th schedule has an interest in the outcome of the dispute. And if this was the case, thus in a case where only one party had a right to appoint a sole arbitrator, its choice will always have an element of exclusivity in determining or charting the cause for dispute resolution. Now, the core, which is directly in point, but not indirectly the other two judgments, because the core dilutes the absolutism in TRF and Perkins on the ground that the unilateral clause it dealt with offered the counterparty a choice of appointing one from a panel. It thus opened the door for upholding unilateral arbitration clauses depending on the facts of the case. The facts prevailing in the intervener's case are far better than the facts in court. Now, this is in the alternative. But the first is that TRF and Perkins were wrongly decided. Then, in the alternative, I'm on better footing than the clause. Now, my lord, public policy is something your lordships talked about yesterday, my lord. There's a public interest element in the lending activities of NBFCs. NBFCs, in addition to wealthy lenders, also lend to segments which banks do not reach in spite of the same prudential lending norms as are imposed on banks. Now, Lord, a large segment of the applicants' borrowers are low-income borrowers whose savings are in gold and particularly gold ornaments. The intervener lends against these assets and thereby assists both the growth of the economy and the capital markets. India's status as the fastest growing economy in the world today is based on domestic demand, which in turn is fueled by liquidity afforded inter alia by NBFCs who reach segments not reached before. Then, my lord, the strength of the capital markets is sustained by retail investors. Several of the small borrowers of the NBFC who pledge gold against loans invest the same in the capital markets where they get a higher rate of return. Now, my lord, the intervener, coming to the facts of this case, and that's my last two clauses. The intervener is a public limited company with a large number of individual shareholders, but I have to protect them. There are large defaults in repayment of loans advanced by the intervener. For recovery of loan amounts between 50,000 to 20 lakhs, there are a large number of individual borrowers who are in such default. The intervener is accountable to its shareholders and hence in respect of these loans has adopted the relatively cheaper and speedier remedy for recovery of their loans, i.e. invocation of the arbitration clause under the loan agreements. A large number of borrowers do not respond to arbitration notices in spite of service of those notices. Almost all the disputes do not require elaborate hearings or trials involving witnesses. Evidence is almost entirely documentary, and the scope of the dispute is narrow as loans and non-repayment of the same are undeniable. Arbitrators are chosen from a panel of lawyers with 10 years experience who have no relationship whatsoever with the intervener or the dispute and do not fall foul of the 5th and 7th schedule. In view of the repeated recorded absence of the borrowers, several arbitral awards are passed ex parte. Come back here now.
It is A1. There even A1.
I'll just finish it. In view of the repeated recorded absence of the borrowers, several arbitral awards are passed ex parte. Few are contested, but no one in the past has ever objected to the appointment of the sole arbitrator. But that's our experience. Nobody has ever said that. It is only after the judgment in Perkins that borrowers at stage of execution proceedings raise the contention that the arbitrator has been unilaterally appointed and hence is ineligible.
What is the profile of your borrowers? They're all
Well, I have
car driver, your small commercial.
None of them are before us.
None of them are before.
They can't afford to.
No, some of them can't afford. But what is the state? I'll tell you, Lordship, but the last clause 8 puts out the alternative.
You are giving the color of law to just giving a formal imprimatur of the law to your actions. That's all.
May I just say this? Look at the alternative. If I'll opt out of your Lordship is
Nominate a lawyer, he'll pass a standard from award, go and see somebody's car, somebody's house, somebody's property.
Two responses to that, if I may, my Lord, because that fell from your Lordships yesterday also. My Lord, the scope of these disputes is not like in those big government contracts where Somebody says there's
The
no performance.
volume is large. The amounts in each individual case may be very small. 70,000, 5 lakhs, 10 lakhs. What is 10 lakhs today in commercial dispute terms? But look at the impact on
Now, what is the counter to that?
society.
What is the counter to that? But kindly just see. Please see clause 8, and that's my final argument, which is some kind of a response, I hope, which prevails with your lordships, to what just fell from your lordships. Please see 8. My lord, there has never been any complaint of, my lord, this is dealing with your lordships, my lord, expressions of the defaulter's nightmare. There has never been any complaint of harassment of the intervener's borrowing during the stage of execution. The question of a defaulter's nightmare situation has never arisen in the case of the interveners. But, my lord, in the absence of arbitration proceedings, the interveners will be compelled to seek recourse to courts by filing summary suits. We can't let it go. We are responsible to our shareholders. Thus, adding to the burdens of the court's arrears, borrowers will be even less prone to contesting summary suits in view of the fact that the option is more expensive and more protracted than arbitration. Finally, my lord, if the defaulter's nightmare does indeed exist, it will equally exist at the stage of execution of decrees and summary suits. I would like.
Yes,
Can I
Mr.
straight away take your lordships to section 2, subsection 6, which, my lords, has not been shown to your lordships now. And that is, in fact, my lords, the guiding light of party autonomy under the Arbitration Act. And it's, my lords, extremely important. Lords, please have a look, take a look at the Arbitration Act. Because this will, my lords, I have 3 submissions. My lords, let me just articulate the submissions. 1, section 2, subsection 6 is the guiding light to understand the extent and the scheme of party autonomy under the Arbitration Act. That's my first submission. My second submission, my lords, is that section 11.2 and the freedom that is granted there has to be read in conjunction with section 2, subsection 6 and is not circumscribed by section 18. And my third point, my lords, is that party autonomy is balanced by the safeguards inbuilt into the Act. And my lords, the last point your lordships has heard sufficiently. I don't need to elaborate, my lords, on the last point. But my lords, if your lordships were to look at my first point, and please have a look at section 2, subsection 6. Because this will also, in my respectful submission, answer Mr. Banerjee's point of the extent to which section 18 can in fact operate. And there is some legislative history. There is, my lords, the model law and how we have departed to some extent from the model law. Section 2, subsection 6, my lords, reads,
Yes.
where this part, except section 28, which is, my lords, the governing law clause that domestic disputes will be governed by Indian law, leaves the parties free to determine a certain issue, that freedom shall include the right of the parties to authorize any person, including an institution, to determine that issue. And my lords, I had filed a set of skeletal submissions in the afternoon yesterday. It's a 3-page skeletal. My lords, if they can just put that up for your lordship's consideration. I have compared that, my lords, with the model law at paragraph, my lords, 4, subparagraph B, which would, my lords, be at page 2. My lords, we also have hard copies here if your lordships would like, but I think your lordships may have that up on the screen. My lords, what the model law set out, my lords, was this. For the purposes of this law, where a provision of this law, except Article 28, leaves the parties free to determine a certain issue, such freedom includes the rights of the parties to authorize a third party, including an institution, to make that determination. Now, while the model law, my lords,
Mr. Balaji Srivastava.
that is correct, my lords. The lordships is right. Yes, I'm deeply grateful. Now, Manoj, how this works, Manoj, in fact, there is some commentaries on this, is this. Manoj, there are about 32 instances under Part 1 where parties have been given the freedom. Manoj, in fact, the entire concept of Part 1 is the amount of party autonomy that is inbuilt into the statute. 11.2 is one example, freedom to agree on the procedure. 2, take, for example, Manoj, number of arbitrators, Section 10. You may make a determination in the contract. You may make a decision saying, we're not making a decision on the contract, but let's assume that we appoint an institution. The institution can make that decision based on the kind of dispute that arises. Again, freedom allows to contract. 11.1, nationality. I might not make a determination when I've executed a contract. Because your lordships has shareholder agreements where, let's assume, investment has come from all over the world. You may not turn around and say that I will not have a neutral national, or you may turn around and say I won't have a particular person coming in. A lot of issues can be determined post lots of dispute arising. The freedom is given under 2 subsection 6. So out of the 32 instances, Section 10 is one, Section 11.1 is one, Section 11.2 is certainly one. Your lordships has seen the terminology of 11.2, challenge procedure. I may decide I have an ad hoc arbitration, but I may decide that an institution will determine a challenge to an arbitrator. I don't want to move a challenge before the arbitrator. I don't want to come to court. That freedom is set out under 11.6. And what 11.6 says is that, but for 28, we will recognize that freedom. It does not circumscribe it to Section 18. So that's my first broad submission that your lordships has. When your lordships, in fact, looks...
What is the subtitle of construction of references?
Yes. So what it sets out, your lordships is looking at 2.6.
Just about 2.6.
Yes. Where this part
is divided into 2 parts. One with respect to scope.
That is correct.
First is the definition part, second is scope, third is construction of references.
Yes.
Have you got that?
I'm just, can I just get a copy?
There is a references to arbitration, I suppose.
That's right.
It's all right, you can tell us later.
No, I'm just sorry. I was just opening the statutory enactment. Your lordships is your lordships looking at the definition is in this part unless the context otherwise requires. And 2.6 says where this part, except Section 28, leaves the parties to determine a certain issue. So one certain is what are these issues? And I've set out that there are 32 instances under Part 1. Which include 11.2, which include 11.1, which include Section 10, which include Section 13, include Section 14. That freedom shall include the right of the parties to authorize any person, and the model law said third parties. We did not adopt the model law. We
simple provision for delegation. If a party can determine an issue, you can delegate the power to determine that issue to someone else.
And therefore, correct. And therefore, I can delegate my managing director to become an appointing authority. I don't have to necessarily delegate it to a third party.
Provided your managing director had the power to appoint an arbitrator in the first place.
That's correct. And that is what your lordships will hold and determine whether that is correct or not. And where your lordships has heard submissions, there is no express proscription.
Thank you.
That's, if we just give another couple of minutes, and I'm not going to take too much time. So that is one part of my submission. The reason why, Section 18 does not proscribe or circumscribe this power is for the very simple reason that Section 18 applies in the case when your arbitration proceedings are conducted. So it deals with the point of conduct. Now, hypothetically, please have a look at the language of Section 18. If I had decided that a particular arbitral institution was going to appoint the arbitrator, that institution had to treat us with equality. Because that is evident from the plain language of Section 18, which uses the terminology, the party shall be treated with equality. So all I'm saying is this, the plain language of 18 is that the party shall be...
Of arbitration.
That's right. Please have a look at the plain language of 18. I'm not going beyond the plain language. The party shall be treated with equality. That's the plain language. Now, if that's the plain language, my lords, I would say that it presupposes a third party. So yes, if I, my lords, go to a particular institution, the institution, my lords, does not correspond with one of the parties. The institution treats one of the parties unequally. But certainly section 18 gets attracted, but that does not prescribe me. So if I, my lords, I'm appointing.
Party here is party as defined under 2H. Party means party to the arbitration agreement.
That's right. The party shall be treated with equality. So it presupposes
A third party. Treatment means there's somebody else who's treating
That's right.
someone with
So
equality.
for example, Mulaz, I have my own managing director. If my managing director does not consult with the counterparty, I can understand. Your lordships may say, sorry, that appointment is bad. But does it
So, but 18 you just said doesn't apply to appointment at all.
That's right. That's my first.
Yeah.
Save and accept. I am willing to, Mulaz, accept that today. I mean, my first argument is conduct. I'm not, Mulaz, elaborating on that. But I am willing to accept that, Mulaz, supposing I go to a particular institution and that institution, Mulaz, has to appoint. That institution may consult with us, may not consult with us. Mulaz, every clause is different. If that institution does not treat both of us equally, your lordships may well say 18 extends to the appointment under 11. Because there may be an...
No, but the moment we say that 18 extends to appointment,
if you're
okay, 11, then we can't say it will extend to an appointment only in certain situations.
No.
Either it extends to appointment of arbitrators, the composition of the tribunal, or it does not.
I'm deeply grateful. Because I have no difficulty with that. Plus, it is Mr. Banerjee's argument that 18 extends to 11. It is our argument that it doesn't. If your lordships is to accept Mr. Banerjee's argument, because I still go and say that it does not proscribe unilateral appointments because the person who's the appointing authority, there is a difference between an appointing authority and the arbitrator. If the appointing authority does not act in accordance with the principles of equality, your lordships may well turn around, or any court may turn around and say, sorry, the appointment is bad.
So therefore, are you therefore conceding that, the equality principle will necessarily apply to this fasciculus of provisions which fall in chapter 2?
I am taking this as an alternative argument. My first argument is the heading is very clear. It deals with the conduct. But my second alternative argument is that should your lordships accept Mr. Banerjee's submission that it goes to 11, I say that that does not proscribe unilateral appointments. That's my second submission. My third submission, as I had mentioned, I don't need to elaborate on. It's there in my skeletals. Your lordships has it. I take it.
Now, anybody else remaining?
My lords, I won't take much of the time.
Yes, Dinesh.
Yes, my lords. Lords, my first submission, my lords, I'm also appearing for one of the NBFCs, my lords. My first submission, my lords, is that when the arbitrability of the dispute has no subjective element and limited to the objective assessment, 11.2 should be given to the full meaning. In other words, my lords, the appointing authority presumes, because Arbitration Act presumes bias. That talks about 11.3 talks about bias, and even 11.9, the Chief Justice may be appointing a person other than some other nationality. That is also a presumption of bias. So my submission is that even if the appointing authority is biased, appointed arbitrator is biased, if the subject matter can be assessed only objectively, there is no subjective element, because this happens in a recovery money simpliciter arbitration proceedings. There, it is not more than an administration of a dispute. It is a management of a contract to a logical conclusion. So it's only what you are trying to find out. What is the schedule of payment? When is the payment? And this, other words, my lords, this can be even fixed by an artificial intelligence process.
The argument is they qualify like a summary suit. You just see that.
It's a recovery simpliciter. What an AI. Imagine if you have a metadata with the values of all this, what is the payment schedule, default payment, what is the interest component, and it would render an arbitration award, which is nothing but an award given by a person, an individual. So when you can read these arbitration awards in a very mechanical manner, objectively, without any subjective element, because 12.2, your lordship is only looking at rule against bias and see that there is any presumption or at least any element of bias. Here, there is no scope for bias at all. So if there is no scope for bias at all, 12.2 should be given full effect. That is my first submission, my lords. And just adding to Mr. Nagul's argument, Diwan's argument, my lords, section 21 starts with unless otherwise agreed by the parties. So unless otherwise agreed by the parties, nothing but 12-2, 11-2. It has been read into, my lords, though it is not specifically mentioned.
Let's now hear the other side.
And then when one more submission, my lords, I will not take. In many cases, I got an ex parte arbitration awards, and my submission is 12-5 proviso. Whenever there is an ex parte awards, my lords, that should be treated as 12-5 proviso because the party did not invoke. So it should be presumed that party waived that 12-5 proviso rights. That's my respectful submission, my lords.
Thank you. Mr. Kaushik. Yes, Mr. Naresh Kaushik.
Invited to my clause. I am facing a situation whereby my awards are not being executed. My clause, in fact, is something better than what is being opposed. My primary submission is that the unilateral appointment is not barred. And the interpretation of section 11(2) is to be seen in the context of section 4 and 5 also, with regard to the interference. In any event, even assuming that unilateral appointment can be objected to, after the stage is crossed, the bar of section 4 puts in, then you can't question it before the court, particularly at the stage of execution that your award is bad. That is the situation which we are facing. Now kindly permit me to read my clause of contract, which cannot be construed by any stretch of imagination to be a unilateral appointment. My clause reads that, as per the terms and conditions of the agreement, it was expressly agreed by you that all claims and disputes arising out of the said agreement shall be adjudicated upon the provisions of Arbitration and Conciliation Act 1996, together with its amendments and rules framed thereunder. Accordingly, we hereby convey and propose the names of below named persons from our panel of arbitrators and request you to exercise your liberty to select/nominate anyone as the sole arbitrator, or alternatively propose the name of the arbitrator from your end to resolve the dispute. We give equal opportunity that in case you do not accept our arbitrator, anyone from our panel, then you please nominate the arbitrator and have this dispute resolved. That may be taken into consideration in the context of the situation which is being faced by me, where.
And on this side, thank you very much.
Yes.
Now we'll call upon Mr. Paul and Mr. Gaurav Banerjee.
Well, may I?
And now everybody else, please give a one-page aid memo. We'll look at it. We have to now. We can't go on and on. If we wait till tomorrow, we'll have another 10 minutes. Yes, Mr. Banerjee. Now we'll have to apply the guillotine. We had to complete the hearing at 3 o'clock.
Written this in. I put it in writing.
Circumstances in
Put it in writing. Yes.
It is in writing.
Yes. Then we'll read it. Don't worry.
My lord, point by point, my lord. Learned SG submissions, very important. Whatever your lordships will decide will have an impact, not only.
Sorry, what are you saying?
My lord, the SG submissions, paragraph 4, references of vital importance, answer will decide a substantial part of future of arbitration. 2, it is whatever your lordships decide is not qua a PSU and a contractor. PSUs may have some degree of government control and my lord, responsibility. It will apply to corporation versus consumer, builder versus home buyer, employer versus employee, insurer versus insured, and finance company versus borrower. If your lordships are permitting a unilaterally drawn up panel, all these cases, which are cases of adhesion contracts, will be squarely impacted.
Okay.
So this is, my lord, the second point.
Second.
My lord, the third point is that.
Lord, I'm sorry, I didn't read, my lord, any of my submissions, my lord.
My lord, please ignore my first submission that it is not important. So,
My
my
lord,
lord,
I'm sorry, my lord, for interruption. Unicitral is dissecting my written submissions, which I never read.
Lord,
I
I'm-
don't think, my lord, this can be
we
the
said it
stand of
before.
Unicitral's regional body.
I'm not referring. Please forget my first point. It is not an important point. Let us leave it aside. My lord, my second point is it will affect all private and public parties across the board. This is, as my Lord Justice Narasimha said, this is a private law area. It will affect all parties across the board, whatever your lordships lay down. My lord, so far as the various US judgments are concerned, to answer, my lord, one point, your lordships will just see one page. I'm not going to read more than one page, my lord. 4316 at volume 3. Please see this. Can it be put up, please? 4316, volume 3. This is, my lord, the heart of our submission. My lords may just see this. 4316, volume 3.
What is that document? Oh, that is Macmillan versus.
Right. Please mark the last paragraph of column 1, the first paragraph of column 2, and the footnote. I'm not going to read it, my lord. This is the heart of our submission.
Macmillan's complaint here.
Complaint, however, goes beyond an allegation of a potentially biased arbitrator because Macmillan cites a lack of fairness inherent in the arbitrator selection process. Supreme Court in Gilmer realized so-and-so. Macmillan's tab contains many of the rules acclaimed by Gilmer for the ability to guard against potential. But unlike the rules considered, tab grants one party unilateral control over the pool of potential arbitrators. Procedure prevents Mija's tab from being an effective substitute for a judicial forum because it inherently lacks neutrality. And my lord, the footnote is also important. I'm not going to read it. The only last point I will make, the rest I will leave for Mr. Kaul, is, my lord, the ding-dong argument on section 18, which is Article 18, which is what I had argued, apart from the other points of, my lord, independence. My lord, the argument that has been put is Chapter 2 is separate, Chapter 5 is separate, Chapter 2 is only to do with appointment, Chapter 5 is to do with conduct of arbitral proceedings, 18 cannot extend to Chapter 2. That's the argument. That's the argument put by the other side on a reading of the provision. Our short reply is Chapter 5 is, my lord, wider. Chapter 2 is, my lord, one part of Chapter 5. What is critical here is, my lord, that Section 18 and Article 8 is based on Article 18. Article 18 commentary, I am leaving, my lord. The Travaux says in so many words, the Secretariat says, my lord, in page 110.10042, the Secretariat says in one line, my lord, I'm reading that line and I conclude, my lord. One more thing I'll say, my lord. 10052. It would apply to arbitral proceedings in general. It would govern all the provisions in Chapter 5 and other aspects such as the composition of the arbitral tribunal not directly regulated therein. This is not commentary in a book. This is how the working group, Uncitral working group, who I represent, and the Secretariat understood the article. Apart from the fact that we have given a couple of books.
Mr. Banerjee, Section 18 is in two parts. The parties shall be treated with equality.
That
right?
part,
and that second part, and each party shall be given a full opportunity to present his case.
I'm relying on the first part.
No, but both parts are very crucial because these parts, both the parts indicate that they deal with the treatment of a party by a third party. Now, who's that third party? The arbitral tribunal. See, the parties shall be treated with equality. When you say both children shall be treated with equality at home, what does that mean? Treated with equality by the parents. You always say treatment is in relation to a third party, not in relation to each other. And each party shall be given by whom? Shall be given by a third party. Who is the third party? The arbitral tribunal.
I'm not relying on the second
part. 18, no, but both are because of the word and. Both parts are joined by the word and. It's
Right.
cumulative.
One,
And therefore, they refer to the treatment of a litigating party, the arbitrating party, by a third party, which is the arbitral tribunal.
my lord, the first portion, my lord, is argued by the other side that it is relevant qua a third party, my lord. I would respectfully say that is not how it has been understood, my lord. It has been understood to cover, my lord, equality inter se between the parties. And we have given, my lord, the
Absolutely. But in the treatment which is afforded to each of them by the arbitral tribunal.
my lord, that qualification is being brought in by the other side. That is a gloss which is being put on by the other side.
Plain reading of the
My lord, I would, my lord, we'll show. Anyway, my lord, one more last point before I hand over, my lord. The provisions which are relied on and the judgments of the English court and of Russell, etc., which are relied on, the English section reads completely differently. 33 mentions what your lordship says, by the arbitral tribunal. There is a direct contrast between 33 of the English Act and 18 of our Act. 33 mentions arbitral tribunal, 18 is completely different. And, my lord, it is the portion quoted by the learned Solicitor General in Russell is half complete. The second portion specifically deals with equality of parties. So, my lord, I will show that.
Yeah. Mr. Potan, yesterday, where did you disappear after Mr. Banerjee argued? You were supposed to have divided time between Mr. Potan and Mr. Banerjee. We'll give you 30 seconds. Tell us what you have to argue.
Just to supplement Mr. Banerjee's statement, I just had reference to the New York Convention, which also speaks about public policy and principles of natural justice. It's all covered in my written submission, my lord. And the 3 ICSID cases, the standard drawn by ICSID in case of bias, I'll just give you the reference of the page numbers, my lord. It's volume 3, tab 142, tab 143, and tab 152. It actually says that the convention does not require an actual dependence of bias. Rather, it is sufficient to establish the appearance of dependence or bias. On the New York Convention, my lord, it's just that the New York Convention precedes the model law. The purpose for having a model law was because there was a difficulty enforcing these awards because there was no uniform legislation. That's where the public policy and principles of natural justice are covered here, and that is addressed in the model law, the right to equality.
Thank you.
Manoj, just very briefly.
Yes, Mr.
Manoj, I'll address only the argument of party autonomy, which has been said runs through like a common thread through the scheme of the Act as a defense their side. Manoj, if your lordship sees the entire debate from the 246 Law Commission report, including parts of the Union of India's synopsis, which has been filed by the learned SG in the matter, all say 2 clear things. Impartiality and independence are critical and essential to an arbitral process. That's a Union of India synopsis. I'll give the page. And apprehension is not actual, neutrality is not actual neutrality, is also an apprehension of bias has to be avoided. And a principle of natural justice, which includes the rule of bias, any arbitral process will be subject to it. This is Union of India synopsis as well. It was this concern of the Law Commission report in the 250-46 report in 3 paras. If your lordships permit, I'll read them out or give the paras, which dealt with it and said that these are creating serious problems. That you are today having people where binding contracts are prevailing over overarching principles of independence and impartiality. You cannot extend the principle of autonomy to such an extent that you disregard the principles of neutrality, impartiality, and independence. A suggestion was made by one of the members to the Law Commission report to say that no, situation should be different in the case of a state. The Law Commission says we disregard that. In fact, the bigger the party and in the case of the state, the degree of fairness, the degree of impartiality, the degree of independence is even more onerous than in the case of a private party in such a case. 12.5 draft was recommended and the legislature in its wisdom picked up the 12 subclause 5 draft in its entirety as recommended by the 246 Law Commission. And the words of 12.5 start by saying, notwithstanding any prior agreement to the contrary. My respectful submission, my lords, is that these starting words are a complete answer to the question and argument of party autonomy. You may have any agreement to the contrary, but the words in 12.5 are notwithstanding any prior agreement to the contrary is contained therein. And if you are hit by 7th schedule, you are per se ineligible. In fact, I read out broadband to your lordships that even you don't have to go under 14 for that. You straight away go to the court and say, substitute him with another arbitrator. Now, the argument sought to be made is that, look, there is nothing in the act which bars party autonomy. 12.5 starts by saying, notwithstanding any prior agreement to the contrary, if you're ineligible, you're ineligible. What did TRF do? TRF and Perkins took it to its logical conclusion by saying that if you are ineligible per se to be an arbitrator, how can you nominate another party unilaterally or curate something unilaterally to the exclusion of the other party? You can't do it. Now, my lords, the other question put to your lordships is unilateral clauses. There is no bar. What is a unilateral clause? A unilateral clause is either the party appointing an arbitrator or his employee appointing an arbitrator. In either of the two cases, he is hit by 7th schedule entry 1 and other entries from 1 to 19. Either he appoints it himself or his employee appoints it. That's what a unilateral arbiter clause is. And that is clearly prohibited by 7. You can't do. TRF and Perkins only go a step further and say, if you can't do it and you're completely ineligible, and Perkins discusses it in para 16 and 15. They say, why? Why can an employee or a person not do it himself? Because he has a direct interest in the outcome of the arbitral process.
Therefore, is it your case, therefore, that the moment a party cannot act as an arbitrator in its own cause, it is fundamental.
Right.
Therefore, you are precluded from even preparing a panel.
Yes.
Without the panel being required to be tested on the touchstone of impartiality.
And unilaterally, you cannot curate a panel.
Is there an irrebuttable presumption that a panel prepared by a party which is ineligible would itself be void?
Malos, may I just straight away answer that?
That's your argument.
And I know there's a good reason. Perkins says that why is ultimately an arbitrator?
Or is it a more nuanced point that, well, though you may not yourself be eligible to arbitrate, so long as the panel which you prepare is a panel which otherwise does not suffer from any of the vices which are provided under the Act, that should pass subject to a challenge in an individual case.
May I just say, Milos, may I just say, and I'll complete with that.
That's the point.
No, may I just show 3 paras are important for your lordships to see because that led to 12.5. I just need to show 3 paras of the Law Commission report. Please have para 53 on page 2756.
And then I have one question.
Yes.
What is the ambit of 13 and 14? How do you distinguish between the ambit of 13 and 14?
Well,
first you come to your point and then end with this. Otherwise I'll forget.
So should I answer that, Milo?
No. First deal with what you were saying.
Yes. 13, 14 are answered in broadband. I'll give that para, which I read out in my opening. I'll give that para to my lords. My lords, please have para 53 on page 2756. This is the Law Commission report, volume 4. This is what led to 12.5 being introduced.
2754.
2756, my lords. It starts at 2737 at 2756. Yes. 2756, para 53. It starts with neutrality of arbitrators, the heading. Yes, I'll learn it right. Just
neutrality of arbitration.
Yes, neutrality. It is universally accepted that any quasi-judicial process, including the arbitral process, must be in accordance with the principles of natural justice. In the context of arbitration, neutrality of arbitrators, that is their independence and impartiality, is critical to the entire process. Then 55. The Act does not lay down any other condition to identify the circumstances which gives rise to justifiable doubts, and it is clear that there can be many such circumstances and situations. The test is not whether, given the circumstances, there is any actual bias, for that is setting the bar too high, but whether the circumstances in question give rise to any justifiable apprehension of bias. The limits of this provision have been tested in the Indian Supreme Court in the context of contracts with state entities naming particular persons and designations associated with that entity as a potential arbitrator. It appears to be settled by a series of decisions of the Supreme Court, see so-and-so, 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 so that arbitration agreements and government contracts which provide for arbitration by a serving employee of the department are valid and enforceable. While the Supreme Court in Indian Oil Corporation versus Raja Transport so-and-so carved out a minor exception in situation when the arbitrator was controlling or dealing authority in regard to the subject contract, or if he is a direct subordinate as contracted from an officer of an inferior rank in some other department to the officer whose decision is the subject matter of dispute, and this exception was used by the Supreme Court in so-and-so to appoint an independent arbitrator under 11, that is not enough. And now the most important para, 57. The balance between procedural fairness and binding nature of these contracts appears to have been tilted in favor of the latter by the Supreme Court, and the Commission believes the present position of law is far from satisfactory. Since the principles of impartiality and independence cannot be disregarded at any stage of the proceedings, especially at the stage of constitution of the arbitral tribunal, it would be incongruous to say that party autonomy can be exercised in complete disregard of these principles, even if the same has been agreed prior to the disputes having arisen between the parties. There are certain minimum levels of independence and impartiality that should be required of the arbitral process, regardless of the parties' apparent agreement. A sensible law cannot, for instance, permit appointment of an arbitrator who is himself a party to the dispute or who is employed by or similarly dependent in one party, even if this is what the parties agreed. The Commission hastens to add that Mr. P.K. Malhotra, the ex officio member of the Law Commission, suggested having an exception for the state and allowing the state parties to appoint employee arbitrators. The Commission is of the opinion that on this issue, there cannot be any distinction between state and not state parties. The concept of party autonomy cannot be stretched to a point where it negates the very basis of having impartial and independent adjudicators for resolution of disputes. In fact, when the party appointing an adjudicator is the state, the duty to appoint an impartial and independent adjudicator is that much more onerous, and the right to natural justice cannot be said to have been waived only on the basis of a prior agreement between the parties at the time of contract and before arising of disputes. And then, my lords, a draft 12.5 on page 2776, 2777 was suggested. That 12 subclause 5 is exactly which is what the legislature adopts in 12.5, as your lordships now see on the statute book. So this was the background, and the Union of India, in the synopsis that it files, your lordships may just note that page. I'm not troubling your lordships with reading it. Their own, the Solicitor General's submissions. Please note page 41, volume 5A. Page 41, volume 5A, para 1, 2, and 2A. If I lordships permit, I'll just read two paras. Kindly have para 1 on page 41, volume 5A. My lords, has that? Para 1. Now let's please have para 1 of this submission on page 5, volume 5A. It says party autonomy is central to the arbitrator process, has been considered brooding and guiding spirit. And then, however, party autonomy is not synonymous to complete autonomy and is subject to principles of natural justice, of which rule of bias is an essential ingredient. Moreover, ensuring independence, impartiality, moreover, However, ensuring independence, impartiality, and integrity of the arbitration is essential to the integrity of the arbitral process. And justice must not only be done, but manifestly and undoubtedly seem to be done. And apprehension of neutrality, lack of neutrality, is also a concern. Now, my lords, the moment you accept that in the light of the 246 Law Commission report in 12.5, which starts by saying, notwithstanding any agreement to the contrary, a prior agreement, Schedule 7 is a complete answer, because that is the prohibition. That's where the prohibition lies. The moment you authorize a person in his own rights who has a direct interest in the outcome of the petition or his employee to nominate or act as an arbitrator, there is a direct conflict, and Perkins deals with it. Your lordships will, of course, go through Perkins and TRF. Perkins says the reason for the judgment in TRF is because the person has a direct interest in the outcome. And lastly, my lords, on that issue of fairness, let me just make two submissions and I'm done. My lords, it is inconceivable to say that impartiality and independence and fairness is integral to an arbitral process, but it will apply to the conduct of proceedings, not to the composition of arbitral tribunal. When your lordships dealt with Lombardi, one was your lordships followed Perkins, but there was another clause which talked about pre-deposit before an arbitral tribunal could be approached. Now, there is no bar in the arbitration agreement, but what did your lordship say? Your lordship said that the court can always, if it's an unconscionable contract or an unconstitutional contract, strike it down. According to me, my respectful submission is that the Act itself provides and says Section 7 is a bar. What you can't do directly, you can't do indirectly. But presuming, and they're taking their case at the highest, that there was no bar, which according to us is there, your lordships could always, on the lines of Lombardi, apply the principle of unconscionable contracts. Article 14, especially where the state or a PSU is involved, does come in. Fairness. Fairness is there, equality is the antithesis of any form of inequality or discriminatory treatment. How can you unilaterally curate a panel and decide on your own and then say it's broad-based? The whole issue that we are attacking is, why can it not be institutional? Why can there not be a general panel for any of the respected institutions that both can go to? Why should you get the right to curate a panel and say, look, I put so many respectable people? The question is not the integrity or the merit of those people. The question is, can you do it unilaterally, and the apprehension that you create of neutrality in the process? That's the issue. Can you do it? And merely because if you're the state. And lastly, my lords, your lordships have said that there have been cases where the PSU have suffered. My lords knows in any number of cases, impartiality is required on both sides, as they have suffered. And I say this with some sense of responsibility. Any number of cases I've appeared in, where the actions of the PSU and their officers were so arbitrary that they brought good companies to their knees in the way they have acted. Naturally, there where the officers are writing on set lines on what they are required to write, raises an equal apprehension on our part. If it raises an apprehension on the part of the state that there's an arbitration award which has been influenced. So impartiality and independence is of equal weightage on both sides. I'm very, very grateful, my lords, for this indulgence.
One sentence only.
We are immensely grateful, Mother.
Thank you very much.
Very grateful, man.
Very erudite submission. We appreciate it.
Very grateful.
Fresh submissions by Friday, by Monday, my lord.